Hello. If you saw my first video, you know my name is Frank. I'm the Leyendecker and Lemire virtual robot. I read Leyendecker and Lemire blog posts. The topic of this presentation is design patents. This post was written a bit over a year ago, but its advice is still very relevant. Please let me know what you think. But before we get started, the attorneys at Leyendecker and Lemire are forcing me to read the following disclaimer against my will. So here goes. The information provided herein is not intended as legal advice. For specific legal issues, please contact us or other qualified attorneys. Now on with the blog post recitation. When most people come to Leyendecker and Lemire with the desire to obtain a patent, they are interested in obtaining a utility patent. Utility patents allow an inventor to protect the functional advantages of a particular machine, article of manufacture, composition, or process. In this sense, utility patents are very powerful tools that prevent the competition from legally offering a product and/or service that reads upon one or more of the claims made in the patent. But there are two other types of patent applications as well. The plant patent and the design patent. Plant patents protect novel and non-obvious asexually produced plants, and as such have little relevance for most inventors. In fact, most patent attorneys have never drafted a plant patent application, and will likely never do so in their careers, my employers included. Design patents protect the ornamental aspects of an otherwise functional article, so long as the aesthetics of the article are not dictated wholly by function. An example is in order. Consider the all-electric Tesla Roadster. Utility patents would be used to protect novel aspects of the vehicle's drive system. Pointy what's under the hood, whereas design patents would be used to protect the distinctive look of the vehicle. A competitor could make a Roadster having a similar look as a Tesla that has a conventional gasoline drivetrain without fear of infringing any utility patents that have issued concerning the Tesla's electric drivetrain. In contrast, a competitor could make an automobile having a similar drivetrain as the Tesla without fear of infringing the company's design patents. In the example, Tesla would want to pursue both design and utility patents to protect its Roadster's distinctive look and technical features. Incidentally, I have no idea what patents Tesla did or did not pursue, although I suspect they did pursue one or more. Historically, design patents have a bad reputation not wholly without merit. For one, they have been, and continue to be used by unscrupulous invention promotion companies as a cheap and inexpensive way to get clients' patent protection. The problem has been that these clients often believe that they have utility-type protection for the functionality of their invention, when in reality only the look of the invention is protected. And in many cases, inventors do not even have a strong idea about what the invention will look like once in production, when the design patent application is filed. As a general rule, design patent applications should only be filed once the look of an invention is finalized, or close to being finalized. Another historic problem with design patents is that they have been notoriously difficult to enforce. I don't recall the exact statistic, but I do recall that a successful infringement litigation pertaining to a design patent is the exception, rather than the rule. I won't go into the reasons why here. Suffice it to say, one had to think long and hard before committing potentially hundreds of thousands of dollars to initiating an infringement action that they were likely to lose, at least based on statistics. These terrible statistics also made it less likely that an accused infringer would settle early, almost ensuring high costs. But this article is about why design patents might be worth the expense, not why they are not. In the past few years, the law concerning the enforcement of design patents changed drastically, based on a decision of the Federal Circuit Court of Appeals. The specifics are beyond the scope of this post, but the probability of successfully enforcing a design patent in the opinion of the attorneys at Leyendecker and Lemire has increased dramatically with this decision. Simply put, design patents now have increased strength and consequentially value, and as such, may be worth pursuing more so than in the past. Please understand that despite the change in the law, design patents are still subject to the specter of misuse as discussed in a previous paragraph. But when properly utilized, they should be seriously considered by the prospective patentee. Often they are best used in combination with a utility patent application to protect both looks and functionality of an article. As an initial consideration, we do not recommend pursuing design protection for an invention until the inventor is confident his/her design is finalized. That is, close to the look of the invention as it will go to market, or the look for which protection is sought, is one that competitors would likely pursue. There are some very appealing advantages to design patents. They are relatively inexpensive. A typical design patent application can be prepared and filed for about $2,000 to $2,500 including attorney fees, whereas the typical utility patent application can cost $6,000 to $10,000. Further, the ultimate cost to obtain a design patent is in most cases under $4,000, whereas the ultimate cost to obtain a utility patent is typically $10,000 to $20,000. Design patents tend to issue much more quickly than utility patents. In our experience, design patents issue within 10 to 16 months after filing, whereas utility patents take anywhere from 24 to 48 months. Further, most design patent applications are granted allowance during examination. Up to 90% according recent statistics. Versus about 60% or so for utility patent applications. Accordingly, if you want to list your product as patented sooner rather than later, a design patent might just do the trick. Given the foregoing, especially considering recent court decision, the attorneys at Leyendecker and Lemire are more optimistic about design patents than before. In fact, I will go so far as to say that when the look of an invention is an important aspect or consideration of the invention, whether or not to apply for a design patent should definitely be discussed with your patent attorney. Please do not hesitate to contact the attorneys at Leyendecker and Lemire with any questions that you may have. See our website www.coloradoiplaw.com or by phone at 303-768-0123. Thank you.